Who we have tonight. Civil rights attorney Michelle Rayner Goolsby joins us from Clearwater, Florida. Also with us, criminal defense attorney Michael Bixon in Atlanta. And from Washington, D.C., in the middle of it all, trial attorney Mark Harold. He's also a law professor and a former police officer. So incredible experience, perspectives that everyone has. Let me start with this first question, okay? Before we get into the grand jury. And this is the question I think is at the heart of why this story is so important and why it continues, okay? Which is criminal charges for the death of Breonna Taylor against the police officer or police officers. Does anyone here have an outline, a roadmap on how a prosecutor could prove murder beyond a reasonable doubt in this case? Does anyone? If you do, raise your hand and we'll get going. Michael does. Okay, Michael Bixon, go ahead. All right, then we'll go to Michelle. Explain to me.
Make no mistake.
Explain to me how you could prosecute beyond a reasonable doubt a murder case here.
Okay, so right now we're seeing with just Officer Hankison, you have the wanton endangerment, okay? And it's not that far of a stretch, at least in this case and based on this fact scenario, to take that and stretch it to something like murder. I've definitely seen cases where you have a fact pattern.
But wait, Michael, I hate interrupting you, but his wanton conduct has nothing to do with Breonna Taylor's apartment. He's shooting into somebody else's apartment.
Again, but the act of shooting itself, okay, and whether it's him or the other officers, if you're talking about someone who's shot to death, okay, as a result of this, I think you can get there.
Michelle, go ahead.
So, Vinny, I do want to say to you that the bulk of my practice is criminal defense. So you got another one. I would say this. Sorry, Vinny, but I will tell you this. How I think you get there is that you start with the warrant. There was issues with getting the warrant. There was issues with the warrant not being truthful, not being factual, that the other individual, they had already arrested this young man miles down the road. There was really no connection between Breonna Taylor's apartment and the young man that they had arrested. That's where I think you start
All right,
at.
Michelle,
I don't even know if you...
let me just jump in for just 1 second because I want to follow up on that. And I've been saying exactly what you've been saying from the beginning. But the way it is broken down here is that the officers executing the search warrant were not the officers who got the search warrant, okay? So is that a problem in trying to hold the officers who shot the weapons responsible? I mean, this is a warrant that was signed by a judge.
Correct. So it definitely was a warrant signed by the judge. And I do think it is hard, and I don't think it's impossible, but I think it's hard if these particular officers didn't know that there was deficiencies in the warrant and deficiencies with regard to the facts. Yes, I understand that it could be harder, but I'm not willing to concede right now, Vinny, but I understand that there could be, with these particular officers, it might be a stretch in order to get a murder charge.
All right, Professor, your thoughts on what happened here. And we understand it's an absolute tragedy. She shouldn't have died. The one thing that I've been stressing to people is that our system of justice is divided into two pieces. There is the criminal part where the standards are difficult and the cases are much more difficult to prove. Then there's the civil part, which deal with lower standards, and it's easier to prove a case when someone has done something wrong. And that part has taken care of this so far, right? Breonna Taylor's death has not been has not gone through our system without some level of accountability. So there is on the civil side. So now we're just focusing on the criminal side. Professor, what do you think?
Well, I think that here's one of those situations where drug enforcement is probably worse than drugs. I think that these tragedies are often too much in the drug enforcement context. But specific to this case, I agree with you. There's a reason that the beyond a reasonable doubt instead of preponderance of evidence between criminal and civil trials is because you're talking about not just money damages, but a deprivation of liberty. And certainly we want to have a high level of proof to deprive individuals of their liberty. In this case, I'd say that there is a roadmap. And I agree with my colleagues that there is a roadmap to get there. I do think it would be a stretch with these officers. And one of the biggest problems would be that any deficiencies in the warrant were not known to the officers executing the warrant. And I believe that they were acting, and I'm not saying about everything that happened, but at least as far as executing the warrant in good faith, that the warrant established probable cause and that the judge had signed it and it was facially valid. In this case, as far as criminal charges, when you're talking about something intentional, I think it's a harder case with Officer Hankison. I do think, obviously, you're looking at tort damages, you're looking at recklessness or wanton, which is when the police chief fired him. Basically, how he said it was wanton to be firing into a building, and he did not think that the officer had a target that would suffice to fire those shots. But I think there's a roadmap to get there, but I think it would be very difficult to get there if you really focus in when the jury's in the box, if they're doing their job and the judge is given the instructions to get past that scienter, to get that necessary level of intent for a criminal charge. I think it would be a stretch in this case.
All right. Now, the focus originally was the police. Now the target is on the Attorney General, Daniel Cameron. Anyone that watched Saturday Night Live this weekend, he was attacked during Saturday Night Live. When does a state's attorney general get attacked during a comedy show? But that's how, I mean, there's a target on him, and people are going after him. He responded on Twitter. I want to put up his side of what's happening here. He said there were a lot of people inside and outside, a lot of celebrities, a lot of folks that are either misrepresenting the facts because it was to their advantage or didn't know all the information. They made conclusions first and then wanted to cherry pick the facts to meet those conclusions. I don't have that luxury as the Attorney General here in the Commonwealth. My responsibility is to the truth and to the information, and that is ultimately what leads to the conclusion. Here's my question, and one question out to everyone again, but we're going to start with ladies first, if you don't mind, Michael, if that's okay. Isn't the ethical responsibility of a prosecutor to only recommend, and everyone's attacking him for not recommending charges. A prosecutor can only recommend charges that you believe you can prove beyond a reasonable doubt, right? I mean, if we have prosecutors that are going in front of the grand jury and recommending charges in cases they don't believe they can prove, our whole system falls apart, doesn't it, Michelle?
Well, I mean, that sounds great and that sounds rich, but you and I both know that there are prosecutors that move forward on cases every day that they know that they can't prove. I've dealt with it as a criminal defense attorney. But I think what the real issue is with Daniel Cameron and this press conference that he did. We're now having grand jurors come out, which, as you said earlier, is unprecedented, never happens. In the years I've been practicing, I don't even recall any time that a grand juror has spoken or has filed anything in order to refute what a state attorney has said, saying that the information that he asserted in his press conference is not what he provided to the grand jurors, and that he's actually not being truthful. And you and I both know that if Daniel Cameron wanted an indictment for the killing of Breonna Taylor, he would have got that indictment. You and I both know that. And that's where I think the issue is. That's where I feel that he's not being forthright with what's going on. And that's why many people, and I believe rightfully so, feel that this whole issue and how he dealt with the Breonna Taylor case was political in nature and not putting the facts to the law and seeing where we get to. Because like I said, if Daniel Cameron wanted an indictment, he would have had an indictment.
The only way I disagree here, Michael, is that prosecutors, and you know, I don't know Daniel Cameron, but I'm going to give him a presumption like I give everyone a presumption that their mind is in the right place ethically when they do their job. But, I mean, it's not about wanting something. It's about what can I prove? What can I prove? And what is the truth of what happened here? And I look at this, and I don't know if this is too simple to look at it. I look at police officers showing up with a warrant signed by a judge, executing that warrant. So they are lawfully where they're supposed to be. They go into the house, and then there's gunfire. One of them gets shot. At that point, my understanding of the law is pretty simple, that if you are lawfully where you're allowed to be and someone is shooting at you, whether you're a police officer or a citizen, you can fire back and return fire. Michael?
Okay, well, there's several issues with the analysis that you're looking at it. And I certainly understand where you're coming from with it. But at the same time, it's not so black and white. Prosecutors have a lot of power, a lot of prosecutorial discretion in terms of what cases they bring and what charges they bring. I mean, if I punch you in the face and you fall down and you die, sure, you could prosecute me for either battery, murder, or everything in between. But just because obviously battery is the easier charge doesn't mean that you can't go with something like murder. So yes, I mean, obviously you can prove a lesser charge, but you can also maybe prove a higher charge.
Well, let me change your scenario,
I mean,
Michael. Let me change your scenario. Let's say instead of you just punched me, right? You punched me in this scenario, didn't you? Right?
in this scenario.
Yeah, in this scenario, you punched me. And if you did, I would fall to the ground. Michael's a big guy. But let's say that before you punched me, I pulled a gun on you.
Sure.
Now, do you want to be charged with
again,
murder? What crime are they going to charge you with if you punch a guy who pointed a gun unlawfully at you?
You can complicate the scenario, and we can go deeper and deeper into this analogy, but the point remains the same, and it's just as valid. Prosecutors have a lot of discretion. Prosecutors have a lot of power. And could he make this a different charge? Absolutely. In terms of what you're presenting to a grand jury, I mean, in this case is obviously very different from what we're used to. We're not used to seeing the tapes, seeing of what they actually present to the grand jurors. I mean, this is like, I've never seen it in my life, right? To get a look inside of how they actually did this, I think is great. The problem is, in looking back on it, now we can sort of look at it and say, could they have gone a little bit further with this? Could they have gone with a higher charge? And I think the answer is yes.
Professor, I'll give you the final word here on the AG here. He's the target now, and they're going after him, and people think he's not doing his job. Some people, others are backing him. What do you think? I mean, is he following his ethical obligations here? Does he have an obligation to do what here? What should he be doing?
Well, he should be seeking justice. I mean, in the broadest sense, he shouldn't bring a charge that he does not think he can prove beyond a reasonable doubt. But I agree, if the standard is just whether he could obtain an indictment, I think we all know that crafted carefully, he'll be able to get an indictment if he wants one. It's an interesting charge that he's brought against Officer Hankison. It's not necessarily one that he didn't have the right to shoot if he had the target, and he was basically had no problem with the background. What he's been charged with, at least a couple of the charges, is endangering the public by firing when he would be endangering someone else that could be hit in the background. So it's an interesting charge in police procedure for not only that can you, as you said, he's there, somebody fires, you can fire back. This charge is actually about not just could he fire if he has that individual in his sights and whether he would be objectively reasonable, use of force, but also did he take the background into account? So it's an interesting charge. It's a nuanced charge to go with, but I think he could have gotten an indictment here. But I believe that he is doing his best to try to go with the facts that he has. But obviously in this situation, it's he's going to get pushback if people aren't satisfied. And I can completely understand why people are not satisfied by departmental policy, officers being fired, and just tort. They feel that somebody should go to jail for this. And I understand that sentiment.
And I told you, folks, we got a great think tank tonight. Much more straight ahead. We're going to talk about a reality television star accused of assault. The trial was supposed to start this week. It got postponed, but we've got all the inside details. And the show that he was on, 90 Day Fiancé.
Well, you guys know I dislike striking trial dates, especially right before a trial date, but it does sound like, despite the party's best efforts, that you guys have come into some discovery that's going to require further investigation and perhaps even further litigation. So under these circumstances, I do find that the motion to continue the trial date is well taken. We will strike tomorrow's trial date.
Believe it or not, folks, we were set to bring you another live trial this week here on your front row seat to justice. It was in Tennessee, involves 90 Day Fiancé star Jeffrey Paschal. It's an assault case, but as you saw, the judge had to delay it because of some discovery issues. But we will continue to track this one for you, and Chanley Painter has the story tonight.
Finally.
Fans of 90 Day Fiancé, before the 90 days, tuned in to follow the budding romance between Jeffrey Paschal and his Russian girlfriend, Maria Molina.
I don't want to die.
They were a popular couple until fans learned that Paschal was facing domestic assault charges. He is accused of attacking girlfriend Kristen Wilson in June of 2019.
The fans off the show got together and said, we don't think that Jeffrey should be allowed to tell all because he has a history of domestic violence. And that swayed the producers, and he was not invited to the tell-all. And we never got to hear if he chose, if he was still with Faria.
Dropped from the season finale, the reality TV star went online and denied the allegations.
I know what happened. I was there.
Paschal told Dominic Nadi, a radio and YouTube host, he was going to fight the charges.
This is all just a ploy. This is all just an agenda to try to make me lose custody of my child.
Paschal is charged with aggravated kidnapping, domestic assault, interfering with an emergency call, and vandalism. According to the arrest affidavit, Wilson said Paschal was in an intoxicated state and assaulted her at her home. Wilson told police he grabbed her by the neck and slammed her head against a wall several times and then thrown to the ground. According to the police report, Wilson was displaying typical symptoms of a concussion, and she was taken to the hospital for further treatment. Police found Paschal at his home. He claimed Wilson's injuries were self-inflicted. Officers arrested Paschal and said that after he was placed in their patrol car, he tried to kick the windows out and needed to be restrained. Paschal says he rejected a plea deal and wants to go to trial to prove his innocence.
And they offered me no punishment whatsoever just to have it on my record. I said no, absolutely not.
All right, we'll continue to track that one for you. Let's bring back in our think tank. And I want to start with law professor, trial attorney, former police officer Mark Harold, who, my understanding, my notes here says you're a huge 90 Day Fiancé fan as well. Is that true?
I'm not sure if that's in your notes, but I have to admit I've watched this show and I am familiar with this couple, and I don't know if that's really in your notes, but it's true. On this one, I can tell you one thing. I would not want, it's an interesting case, I guess more because of the show and the backlash against him from the fans and all that. But he's certainly not making it easier on his defense counsel to be doing this kind of interviewing, talking. I read somewhere that he stayed up all night and replied to every direct message to him and emails. And so that'll make it very difficult. It's, obviously it's a kind of a he said, she said case to the point of cross claims of self-inflicted injuries. He thinks it's a conspiracy, I guess, for custody. But I have some familiarity with this couple back when he went over to Russia and back. And so I was not surprised when I saw this case pop up that he was fighting it. He had made some statements to that effect.
Yeah, you're surprised how in-depth our background goes when we bring you on as a guest in the show. Michelle, let me ask you. It was a wild guess, and I got it right. All right, Michelle. Michelle, he is according to him, he's rejecting a plea deal with no punishment. He's facing up to 30 years. So what does that tell you if he's coming out and saying, I will not take a deal on this assault case? I don't care if it's no punishment. I want my day in court.
Well, it can mean one of two things. And I want to say I actually am a huge fan of 90 Day Fiancé. And so I'm very familiar with this couple. It can mean one of two things. It can mean that he really, truly didn't do it. And he believes that he's innocent and he wants his day in court. He doesn't want this on his record. Or it can mean that he thinks that he actually did do it, but he thinks he's smarter than the jury and that he's a good looking guy, that he may be able to charm the jury and he wants his day in court, because ultimately, as we know, it's the prosecutor's job to prove their case. He doesn't have to sit there and say anything. Literally, I've said it in trial. My client could sit here and he and I could play, hangman or whatever, and he sits here innocent. So it's his right to go to trial. But to the law professor's point, I would be very upset with him for commenting and DMing and all of those things, because I know when I get jail calls from the prosecutor in my cases and they hand me the jail calls as we're set to go to trial, that's like, I can't, so I would be furious with him, and he needs to be quiet, because what we all know is that somehow, some way, a prosecutor is going to find it, and it's going to discover it to defense counsel, and it's going to come up, especially if he says, things that are, contradictory, and it's going to go to his credibility. So he needs to be quiet.
Yeah, well, he can be very convincing. He's convinced 3 women to marry him, but then they were convinced to unmarry him. Michael Bixon, I want you to take a listen to his defense attorney explaining what the defense is going to be here.
Well, it's important to note that Mr. Paschal has entered a plea of not guilty to each and every count of the indictment. So our position is very simple. It's very straightforward. Mr. Paschal did not commit the acts for which he's accused. Our investigation corroborates a lot of that information, and Jeffrey looks forward to his day in court. Just stay tuned, and you'll see when this proceeds to trial. I don't anticipate it's a case that's going to be resolved, barring some unforeseen circumstance. So we're eager to move forward.
All right, he could be even more vague, I think. But Michael, based on the nature of what this is, 2 people, in a room together, an assault, we know that the accuser, the alleged victim, is going to come into court and testify. Do you think they can win the case through cross-examining the victim in the case versus him getting up on the stand and convincing the jury that there's a reasonable doubt?
I think cross-examination is where it's going to be at. I think the hardest problem they're going to have in this case is if there's actual physical proof, pictures, video that show her injuries. Because if there are very bad injuries to her elbows, to her knees, that's a really bad sign for his case, because it is very indicative that, yeah, she was dragged around by him. It's going to be very difficult for him. Now, I understand that he has an argument about, her motive behind this, at least according to his defense team, that, this is really about custody and her getting back at him. And I've seen it play out before. I mean, God knows I've handled plenty of cases where there's a divorce going on while there's a criminal case, and they are the most contentious criminal cases. I mean, more so than any other criminal case I'll ever handle is when there's a divorce going on or there's a custody issue going on. So I think that, they can pull out a motive, something like that on cross. I'd be very hesitant to put him on the stand. I think that the state is going to have a lot of ammunition against him. We know there's priors, the TPOs, obviously all the messaging he's doing, sending all this stuff out, the tweets, the videos. That is not helping his case. If I was his attorney, I would be pulling out my hair every time I saw him do it. So, I don't necessarily know about putting him up on the stand, but cross, I think they're going to have a very good opportunity with that.
All right, well, we did ask his attorney if he's going to testify. Let's see if he can be even more vague here. Take a listen.
That's a decision that we're going to make after we hear the state's proof, evaluate whether they met their burden. As you know, the citizen accused never has to prove their innocence. And if we think the state has reached, has made some headway, then that's a decision that Mr. Paschal and I will make in concert. But we definitely have not reached that decision-making point yet. But in this case, there are only 2 people that know what happened, and that's the alleged victim and Mr. Paschal.
Mark, I think he is going to take the stand. I really do. I think he's got that personality. It's what draws you to be on a reality show. It's what gets you in and out of marriages. I think he's going to end up on the stand.
Yeah, I think he'll end up on the stand too, and maybe even over his lawyer's objection. One of the problems he's going to have is not just the priors, but he actually could be, without, I guess, the priors and some other things, but he can actually be an effective witness. He is kind of a charming guy. He comes across well generally on the show, but the problem is coming back to he's made so many statements. He's done interviews, he's made statements, he's tweeted, he's texted, everything. And it's very hard for anybody, even if they're trying to tell the correct story, not to contradict themselves. So I'm pretty sure that his credibility could be undercut severely with all the exposure that he's had. If he had not taken all these steps to go public, he might be an effective witness for himself in a he said, she said, but I don't think he can take the stand now. But I agree with you. I don't think that his personality will let him stay off the stand.
All right, and I think the big issue at the trial will be, will Varia, however you say her name. Varia, will she show up, and which side of the courtroom will she sit on? That's what we'll be looking out for. All right, folks, so when we come back, we're going to take you on the docket. Case that we're tracking out of Utah, tragic case involving a 25-year-old woman, goes on a dating app, ends up dead. On the docket tonight, the Tinder date murder trial. And this is a tragic, tragic story out of Utah involving a 25-year-old woman, goes on a Tinder date, ends up murdered. Chanley Painter has more.
We have a male on the line saying he wants to die and that he killed someone.
The 911 call coming in after 3 a.m. in the morning of May 24th. The caller, 24-year-old Ethan Hunsacker, is back from a Saturday night date.
They just met on Tinder that night, had gone out for some drinks, and had ended up back at his house where they planned to watch a movie and spend some time together, which they did.
Police say his date, Ashlyn Black, fell asleep at his house.
And at one point he woke up and for some unknown reason, completely unprovoked, he decided that he was going to kill this young woman, and he did.
When officers got to Hunsacker's house, investigators found Black's body with multiple stab wounds.
Blood on the floor, looks unconscious.
Hunsacker allegedly told police he choked and stabbed Black. He was arrested and charged with her murder.
But certainly, by his own admission, had some demons that he was dealing with.
Investigators say Hunsacker admitted he has homicidal and suicidal thoughts daily and is on medications for mental illness. The explanation brings no comfort to Black's family. Their statement saying in part, quote, "A monster has taken away the life of our little girl in a crime as senseless as it is evil. Our hearts are broken and our lives forever changed due to the despicable acts of another person."
We haven't had a case like this where complete strangers meet like this. In the time that I've worked here, 23 years, we've never had a case with that, set of details.
Absolutely difficult case, and you talk about evil. This just seems so evil, so senseless in what happened here. But we've got some seemingly overwhelming evidence. Let's bring back in the think tank. Michael Bixon, I'm going to start with you. This is a case where forensic evidence exists, digital evidence exists, and oh yeah, we've got the confession found at the scene of the crime, all that other stuff, right? So from my perspective, it seems very overwhelming. But under the current charges that he's facing, it looks like it's 20 to life. So he's not going to be given any deal here. This thing will go to trial. What on earth is the defense going to do with this one? How do you approach it? And what are those conversations like with Ethan Hunsacker?
We already know that there's some type of mental health issue going on. And from what we've heard from his defense team, they are planning to pursue some type of insanity defense. It's a very hard defense to go through. I mean, a lot of people hear that and they think, oh, well, it's just an easy cop out and they're going to dismiss the case and that's it if they think he's crazy. Very, very few cases end up going that route from an insanity defense. It's a very, very hard thing to do. I know that his defense team is already sort of bringing up some of those preliminary issues. I'm sure that's a road they're going to go down. I don't think it's contested here that he did it. It's fairly obvious. But I do think they have a shot at it if they do go down that road. There's some issues with it. Obviously, he knew what he did was wrong. He called the police. He admitted it. He wanted them to come there and to take his life because he felt what he did was wrong. So there are a number of issues with it if they do go down that road. But, I don't see what other choice they're going to have at this point.
Michelle, let me ask you how difficult that conversation is with a client, right? And a client who suffers from mental illness. And you've got to say, listen, you're mentally ill. I represent. What do you mean? I mean, sometimes people who are mentally ill might not, be on the same page with you about the status of their mental state. Maybe they are sometimes, but maybe sometimes they aren't. But how difficult is that just to deal with that issue? Because you've got to have that conversation, don't you?
I mean, you're absolutely right. You have to have that conversation. It's a conversation that I've had many times, and this kind of brought me back to a recent client that I had where it was very hard for me to communicate with them to the point that, here in the state of Florida, we had to send them to the state hospital in order to get competent enough to even understand or appreciate, as the law says, the charges that that they had, and it is a hard conversation. So really, it depends, where he is, where his mental health is, and I would say this: I do think that there is a world where this may not go to trial, and I'm not saying that they would plea out to 20 years, but because of how heinous and how just despicable this crime is, he may plead to a large number that the family would be okay with, just to spare them from going through a trial and to spare them from hearing those details. Because I think it's, as Michael said, it's not disputed that he did this. He admitted to this. Everything leads to him. But I think that there may be a world where the family members may not even want to go through a trial because of the facts of the case.
Mark Harold, are you surprised with where we are right now in this case, that this, number one, isn't even death penalty eligible based upon the way they're charging it? It's not the most serious murder charge in Utah. That right now facing 20 to life, and I'm shocked by that myself. What are your thoughts about the way this is being handled right now? And do you think it might change down the road? Maybe go for some sort of upgrade in the charges?
Yeah, they may have left themselves some leeway in the charges to get through and figure out exactly whether they can address some type of diminished capacity and insanity plea. Obviously, insanity and self-defense, those types of pleas can be problematic. You pretty much have to admit that you factually did it to make these assertions that you're not legally responsible. But it doesn't seem to be a problem in this case, because it's pretty clear that there's evidence that he committed these acts. Just like Michael said, I mean, you have a situation, somebody calls the police and they actually are suicidal. It's hard to show that they didn't, the legal standard of right and wrong versus what people may say as a layperson, that person is, crazy or insane. But I'm not really surprised. I would say that they have reasons, given how heinous this crime was, they have reasons to charge it the way that they did. I would, think that given the fact it also involves social media, and there have been cases, and there's certainly a problem with people sort of feeling that they know somebody before they even meet them in person. This might be a case that prosecutors would be very interested in. So it's not charged to the maximum, and I would assume there's a reason for that, a strategic reason for it.
Yeah, again, this is one we will continue to track here on Court TV. Utah versus Ethan Hunsaker. We've got a preliminary hearing coming up October 28th, so we should learn a lot more during that prelim, a lot more about some of the facts and perhaps some of the arguments that will be made by both sides. But there's no trial date. As a matter of fact, in the whole state of Utah right now, there really are no trials happening. And word that we got earlier tonight, was that it looks like it may not be till next year that some trials begin to happen in that state. Of course, you'll hear about it first right here on your front row seat to justice. When we come back, time for our 13th juror to weigh in. And I posted a video today from Beverly Hills. You had a vice president, an executive from Versace, who was doing some shopping at a Versace and did some jaywalking, ends up being stopped, detained, and searched. And yes, we've got the video and your reaction next.
So what do you want me to do right now? I just wanted to see if you had any ID, but without reaching into your pockets.
I do have an ID.
Awesome. Do you have any weapons or anything?
I do not.
Okay, do you mind if I just
You can do whatever you need to do, man. I'm just nervous. Can I put it down my phone at least?
Absolutely, yeah. No worries, man. What's your name?
Salehi.
All right, I'm Officer Krug, man.
Nice to meet you, bro.
I'm just going to check to make sure you don't have any weapons if you don't mind, okay? Face that way real quick. Put your hands behind your back, palms together like you're praying. Awesome, thank you. All the way like you're praying, Interlace them, Spread your feet. Cool, man. Don't want to mess up those shoes. Those are pretty nice. You said I can search you, right?
You do whatever.
Cool, man.
This is embarrassing, to be frank. Am I good to go?
Yeah, you're good.
All right, you guys have a good
Next time, don't change the narrative like that, though.
All right, let me give you a little more of the backstory in case you don't know. That man is an executive with Versace. He had a Versace bag in his hand, was just coming from the Versace store on Rodeo Drive in Beverly Hills. And apparently maybe had jaywalked, was stopped, was asked for identification, was searched, detained by police for 3.5 minutes, posted the whole video today up on Facebook. Incredible reaction from the 13th juror. We begin with our comment of the day coming to us from Mark. And Mark writes tonight, the only thing missing was Barney Fife coming in and writing a ticket. They thought he had stolen something. I support the police, but they are not helping themselves with this kind of stuff. All right. Does anyone know who Barney Fife is? All right, Michelle's got it. Michelle, all right, you know who Barney Fife is. What was going on here? What did you see in this video?
So when I watched this video, I got really upset for him. He was jaywalking. All they had to do was say, listen, you jaywalked, don't do it. I jaywalk all the time. I mean, it happens. Like, all of this for jaywalking is just ridiculous. And maybe because it's Beverly Hills, they don't have anything else to do. I don't know. But literally all of that, to search him, to ask for ID, to take it to that extent, to detain him for jaywalking, either write him a ticket or just let him go, or say, hey, listen, you jaywalk, don't do that again. I get his frustration, especially in the climate that we're in now in our country. I get it. I think that it was just utterly ridiculous.
Yeah, and hey, look at this. We're agreeing, Michelle. How about that? We agree. And it has nothing to do with what's happening in the country now. I mean, at any point, if this happened to anyone, it's well, all right. Lori's comment tonight. She writes, "That is not okay. Don't they have better things to do besides harass someone for jaywalking? With all that extra time on their hands, maybe they should be taking some more training courses." Just a thought. Michael Bixon, why do you think he was stopped? Was he stopped for jaywalking?
It was a pretextual stop. I mean, and to be clear for everyone who's watching, the police officers can follow you. They can wait for you to do something wrong. You know, if they see a black guy, they can follow him for blocks and blocks and blocks, wait for him to maybe jaywalk, and then stop him. And then in a very nice way, ask, oh, do you mind if I see your ID? Can I search you? And go on and on and on, all over jaywalking. The issue wasn't that he jaywalked, it's that he's black. I mean, this whole thing is ridiculous and so over the top. All this for jaywalking? Come on, give me a break.
Ashley tonight writing, it is okay. The cop stated why he wanted to stop and talk to him. Clearly a bus right there. He was doing it for his safety. He wasn't paying attention like most on his phone. He said he was following his GPS. Anytime a police officer stops someone, they have to run their identity to make sure no warrants, etc. Protocol. The police officer was extremely polite. Good job. Mark Harold, do police have to run the ID anytime they stop someone?
Well, when I was an Atlanta police officer, I know that's where Michael is. I don't know that there was that anytime we stopped someone, we absolutely had to run the ID. We normally would to see if there were wants or warrants out. But, you know, this situation is one of those, there's nothing better than a good cop and nothing worse than a bored cop. What doesn't make sense to me here is that they did not need to make an investigatory stop, well, you know, what somebody might call a Terry stop, or continue down with to frisk him. What they had there was ostensibly they were stopping him for a completed crime that they had probable cause for. Now, I think that's ridiculous, and I think it was clearly pretextual. But they had a completed crime. If they were going to stop him, then they should have immediately moved to issue a citation. I don't think they'd make a physical arrest. And in that, because of the close conduct, they could frisk him if they had separate articulable suspicion that he was armed and dangerous. But here, the sequence is that they had a reason to stop him, but they didn't pursue that. It's not clear why, if it's important enough to stop someone for jaywalking, it's not important enough to write the citation. The other thing here, though, when you really get into the nuts and bolts, what would be interwoven with this would be the statements made and whether this turned into a valid consensual encounter.
Oh, I think he froze up.
You heard what he was saying, so.
All right, great job. I said we had a great think tank tonight. Did not disappoint. Michelle Rayner-Goolsby, Michael Bixon, Mark Harold. Thank you all. Please come back again. That's it for tonight, folks. We'll be here again tomorrow night. Supreme Court tomorrow here on Court TV. Have a great night, and don't forget to hug the kids.